Well, good afternoon, everyone. Welcome to the overview of the standards of practice for condominium management. I will mention that we are recording this session for purposes of putting the presentation on our website eventually. So, but that doesn't change how the presentation will be presented. So we'll just use our regular format. So starting out today, here's the agenda of what I'm going to cover, and there's a lot to cover in the next while. So as this is a very wordy presentation by the nature of the content, for some slides I'll move along very quickly, and others I'll spend more time giving an explanation or background for the rule. There will be 3 opportunities to have questions answered on the standards of practice, and a final opportunity to ask questions on the regulation of condominium manager project in general. Deborah Howes, in addition to chairing this committee, has had a long time involvement with the condominium community. Deborah will join me in responding to questions or points that get raised during the webinar. As for me, I have worked in many facets of the real estate industry over the last 38 years. This includes condominium sales, working with developers, and 24 years as a regulator dealing with the condominium issues that involve condominium corporations, boards, and unit owners. Currently, I live in a Barrowland condominium and have served on our corporation's board for the last 7 years. This familiarity certainly helps me with understanding the issues around condominium management. RECA has been responsible for the regulation of the real estate industry since 1996. Its main focus is promoting the integrity of the industry and protecting consumers. This has been accomplished through licensing standards, education, practice review, and compliance. Once RECA was tasked by the provincial government to regulate condominium managers, RECA set up an advisory committee to develop a structure, standards of practice, and create rules for the regulation of the condominium management industry. You can see that the membership of this committee represents a broad cross-section of the condominium sector, including condominium managers, owners, and public members. Here is a high-level history of how the regulation of condominium management has progressed. So in September of 2013, RECA had discussions with the Service Alberta, and it was decided, to move forward with the regulation of condominium management under the Real Estate Act. In December of 2014, the provincial government made amendments to the Real Estate Act that have not yet been proclaimed, but when they are next year, it will give RECA the authority to regulate the condominium management industry. In May of 2015, the advisory committee that I mentioned was created, and it had 12 members originally, and the government asked that we add 2 more unit owners to the mix. And then from October 2015 through January of 2016, RECA carried out the phase 1 consultation. And this phase was to look at the regulatory model, the licensing structure of what regulating condominium management would look like. In April of 2016, the phase 1 consultation was complete. The committee assessed the feedback from the consultation and then made recommendations to the Real Estate Council, and the Real Estate Council approved those recommendations for moving forward. In December of 2018, work on phase 2 began, which includes the standards of practice, service agreements, insurance and bonding, and exemption regulation. And I'll speak to all of these in much more detail as we move forward. Then in August of 2020, the committee wrapped up its work on preparing for the phase 2 consultation, and the consultation opened on October the 14th and runs through to November 12th. And this webinar is part of that consultation process. So as we move forward, you can see there are still several significant steps that need to be completed before licensing and the regulation of condominium managers can take place. This includes approval of the rules expected to take place in the January-February time period of 2021, course and course materials are not expected to be ready until at least the spring of 21. And then eligibility requirements are expected to be finalized by around March of 21. If all these pieces fall in place, along with the exemption regulation, which I'll speak to in a minute, if they all fall in place, then our expectation is we will be licensing condominium managers as of December 1st of 2021. We had hoped to be doing it in the May to June time period of 21, but government has given us notice that they're not going to approve or proclaim the changes to the act that we need in order to regulate condominium management until December 1st of next year. Expectations are that Bill 20, which amends the Real Estate Act, will be proclaimed in early November. So this bill was passed back in June of 2020 to make several changes to the Real Estate Act. I'll talk about different pieces of this as we move forward, but an example of the terminology changes, for instance, in the existing legislation, regulations and rules, we use the term industry member as a generic term for everybody that's licensed under RECA. That will be changed to licensee, excuse me, under the with the changes from Bill 20. Also, the rule making authority route has been changed, and the development and delivery of education courses, which are currently carried out by RECA, is going to be moved to third-party providers. And so the first big impact of that will be the courses for condominium management will be done by third-party providers. The new governance structure is a big change, and it will go from the excuse me, current 2 public members and 10 industry members to a total of 11 public members and 12 industry members. The chairs will be public members. Each sector regulated by RECA will have an industry council. Condominium management will come under the Residential Property Manager Industry Council. So you can see there's a council for residential real estate, for commercial real estate and property management, a third one for the mortgage brokerage industry, and then residential property management will include residential property managers, so for individual houses, apartments, and also the condominium management industry for both residential and commercial condominium complexes. The election of industry members to the Industry Council is currently underway, the process. As condominium management is not currently regulated and condominium managers are not licensed, it is necessary to implement a temporary licensing process to allow condominium managers to be involved in and elect representatives and have their representation serving on the Residential Industry Council. And conceivably, that person who serves on the Residential Industry Council could be appointed by that council to also represent that council on the board of directors. So this is, as I said, a temporary licensing. It's only for the purposes of the election process and for people to serve. There's no license fees involved, and condominium management will not be regulated in any way as a result of this temporary licensing. This definition of condominium management will be inserted into the Real Estate Act with the amendments to the Act are proclaimed to include condominium management. So condominium management services means the exercising of a power or the performing of a duty of a condominium corporation on behalf of that corporation. And it can include all or any of these depending on what the corporation and the brokerage decide is most appropriate in a specific corporation situation. So the most common are collecting, holding, and dispersing contributions by unit owners and paying bills of the corporation, enforcing the bylaws and rules of the corporation, negotiating or entering into contracts on behalf of the corporation, and lastly, supervising employees or contractors that are hired to carry out work for the corporation. So there's no requirement that these all be included, but with whatever service agreement is signed between the corporation and the brokerage, they will decide, that will stipulate what exactly the brokerage will be doing on behalf of the corporation. So I mentioned phase one earlier, and the issues bulleted here were approved by council in the previous phase one work. Bonding and liability insurance have changed since the original decision and will be covered later in this webinar. In order to simplify this presentation, I'm going to drop the word condominium manager, but under our licensing structure, we have condominium manager brokerage, which is the company, the legal entity carrying out services for condominium corporations. We have the condominium manager broker, who is the manager / supervisor responsible for overseeing both the So I'm going to go over the specific rules tied to the standards of conduct, and they're quite detailed. In order to keep this presentation moving along fairly smoothly, I've highlighted in many of the slides certain parts of the phrasing or wording in blue to bring out the most important points that I'll focus on. For anyone that's interested in the full detail of the rules, on the RECA website under the consultation, you'll find Appendix A, which shows all the places where condominium management has been inserted into the existing rules. RECA takes a principle-based approach to rules. Rules are not created to cover every detail, but capture the main principles. Industry members are required to go further than just meeting the requirements of the rule, but also the spirit of the rule. Please note that, again, that I've highlighted the most important points. Now, just to touch on this point about being principle-based, I could tell you from my experience in working with the International Regulatory Organization for Real Estate Regulators and seeing what goes on over a many-year period in other jurisdictions, and also with my familiarity with how government deals with a lot of issues. They create rules, and then when somebody finds a loophole to the rule, they plug the loophole with another rule. And then somebody eventually finds a loophole to that rule, and they create another rule to plug that loophole. And it's just a never-ending process, and you end up with just reams of rules, and it gets very complicated. So the approach that has been taken by RECA is principle-based and at a high level. It can still deal with all the details, but it's up to industry and best standards to deal with what's expected. There are high-level responsibilities and prohibitions that currently apply to all sectors regulated by RECA. These will also apply to condominium managers. Some of these requirements come from contract law, other are regulatory requirements. I don't think anyone would be surprised by these responsibilities and prohibitions. So you can see in the left column here are the responsibilities, and you would expect people to act honestly, provide competent service, cooperate fully with counsel, comply with the terms and conditions of their license, complete education as required as an industry member. But then there are the prohibitions, and again, nothing surprising there. You would expect that we would prohibit misleading advertising or representations, fraudulent activity, discouraging people from seeking legal or expert advice, and so on. So these responsibilities and prohibitions apply to everybody that's regulated by the Real Estate Council. And as I said, will also apply to condominium managers. So some other general standards that are in place currently that will also apply to condominium managers. The first one here on this slide, the protection of client information. RECA takes disclosure issues and privacy issues very seriously, and licensees cannot disclose information that's confidential or personal unless they've been authorized to by the person or the board, in the case of condominium corporations, to do that. And it also, the other stipulation, I guess, would be if it's required by law that something has to be disclosed, but that doesn't come up very often. So brokerages are expected to have policies and procedures and training in place so that their staff are in line with what's required under the disclosure and the personal privacy issues. Referral disclosure, so it may not happen as often in condominium management as it does in the real estate side, but it could happen. And referral would be if either a unit owner or a corporation or a board of directors is referred on for whatever reason. It might be to third-party providers or whatnot, but there has to be permission to refer information. So a condominium manager may hold information about unit owners or about confidential information that the board is discussing. And again, if it's part of a referral, then it can only be done with permission. And if the brokerage or the industry, or sorry, the condominium manager is going to receive any kind of remuneration back for the referral, that has to be disclosed to the party who's authorizing the referral, and they have to be okay with it. And then support personnel and assistants can only be assigned tasks that they're competent to carry out. So if it's a licensed activity under the Real Estate Act, then it can only be assigned to a licensed person. So the brokerage or condo managers cannot be assigning any tasks that must be done by a licensed person to an administrator or an assistant. Rule 43 is an existing rule, and it's very important. Before a condominium brokerage can provide any services to a condominium corporation, there must be a service agreement executed between the condominium corporation and the brokerage. It is extremely important that there be documentation detailing who is responsible for what. So this currently applies to other sectors, but it will also include condominium management when we start regulating condominium managers. And the next portion of this, part 2 of Rule 43, provides for the details of the main components that have to be included in a service agreement. So again, there would be no surprises here from a contract law perspective. You're identifying all the main components that would have to be in a service agreement, and you know, who the corporation is, who the brokerage is, the start and stop dates of the agreement, how the agreement may be terminated if it's going to be terminated prior to its natural expiry. Again, what funds or fees the brokerage will be paid for the services it's offering. So all of these things have to be detailed as part of the service agreement. But in addition to these general requirements, there's specific requirements that apply to condominium management. So a new rule has been added in that specifies what's, in addition to what's in Rule 43, what's specific to condominium management. So first of all, this first part here covers off if the brokerage is going to be holding money that belongs to the corporation, it would hold it in trust in one or more accounts. And later on in the webinar, I'll come to details over these accounts. The service agreement also has to include terms of termination. So what happens if either party is not happy with what's taking place and they choose to terminate the agreement, how that process works, and what must happen at time of termination, as well as what happens at the time of termination on the natural expiry of the contract. Any additional fees for services also have to be specified. So there would typically be a monthly service fee charged by the brokerage that would be in the service agreement, but there could be other instances where there'd be extra fees charged, and they must be provided in an addendum to the service agreement. So an example of that would be board meetings. So a typical service agreement might say that the condominium manager will attend and participate in 6 board meetings a year, plus the AGM. And if that's what the contract says, and that corporation ends up having to do, let's say, some major work at the complex that involves a lot more time, a lot more discussions by the board, then they may request that the condominium manager participate in extra meetings above and beyond the ones that are in the contract. And if that's the case, then in the addendum, there would be an amount specified for what it costs for any extra meetings the condo manager has to participate in. And then lastly, any authorities the condominium corporation delegates to the corporation, to the brokerage and the condominium manager. So it has to be clear what authority the corporation is giving the brokerage to carry out on their behalf. And then under scope of authority, there's several issues. So will the brokerage and the condo manager be signing checks and making disbursements on behalf of the condominium corporation? Will they be given the authority to enter into contracts again on behalf of the corporation? And would the board want the condo manager to be the one investing money on behalf of the corporation? So these all would have to be specified in the service agreement. Also, the timing, frequency, and nature of accounting statements. So you'll see later on in the rules, there's a specific point where we have a rule that says this is the minimum that a brokerage has to report back on a monthly basis to the board. But a board might want much more reporting than the minimum, and that can happen. They just would negotiate that into their service agreement with the brokerage. The service agreement would also detail what records are to be kept by the brokerage. And also this last clause is a little bit of an oddball, but it's around specifying that interest on trust accounts must be paid to the condominium corporation. And that's there for a couple of reasons. there was an oversight when changes to the Real Estate Act were made, and this wasn't dealt with in a clear and precise manner. So this is going to be a clause that will be required in service agreements so that it's crystal clear. But in property management, general property management, there may be instances where a property management brokerage is holding funds on behalf of a landlord, and some of that interest may be directed to the brokerage instead of to the landlord. Or in the case of real estate sales, interest on deposits on real estate transactions is paid to the a fund, a real estate fund that's managed provincially for goods that are services that are a public good in many different types of services. So interest can go in many different directions under the Real Estate Act, but in the case of condominium management, the interest must be paid to the condominium corporation. So that brings me to the end of the first section that's on the general standards and written service agreements. Are there any questions at this point?
Nothing in the chat, Doug, so maybe if Jim or Rick have any questions they just want to ask you directly.
Hearing nothing, I will move along.
Doug, I'm not going to let you off the hook.
Oh,
I'm just
okay.
Since you and I've had many discussions. Just a reminder to me, as I listen to you, in terms of the specificity or the specific nature of I guess the clarity of the services to be provided. And I've been wondering that lately, just how specific do we get in contracts for things like snow removal, I mean, the seasonal types of things, lawn maintenance, that sort of thing. Should that be done in some generic statements, or do we have to be specific to say lawn maintenance, snow removal, and maintenance projects, reserve fund projects, that sort of thing?
So those types of things would be covered under the section that says what scope the board is giving to the manager for third-party contracts. And but generally the details for snow maintenance or landscaping or other types of work would be in the contract that would be put in place between the corporation and the provider of that service. It wouldn't be in the service agreement between the brokerage and the corporation.
The reason I ask that is getting at the fee. You know, in other words, if you're paying a monthly fee, my notion is that that's inclusive of these types of activities. And that's why I'm asking how we cover that. I mean, I get it in terms of putting that sort of thing in the addendum. I guess it comes right down to the question of how do we clarify that with a condo management provider?
Generally, the overseeing of the third-party contractors for the routine issues would fall under the general service agreement and the fee that the brokerage is charging. It wouldn't be an add-on.
Okay.
Add-ons would typically be if there was a big project under the reserve fund, for instance, to completely redo the envelope of the building. Yeah. Then there might be an additional fee charged. But for most routine services, whether it's cleaning and general maintenance, snow removal, or landscaping in the summer months, overseeing those activities would typically be part of the general service agreement fee that's charged by the brokerage.
Okay, thanks, Doug.
So I'm going to move on to the standards of practice, and on this first slide, there's a few general ones. So a brokerage can only provide services in the name that is registered with RECA, licensed under. It can't provide it under other names. The name of the brokerage always has to be clearly indicated on all documentation involving the brokerage, including the service agreement and any other documents that are created, so that it's very clear who the corporation is dealing with. And the brokerage cannot provide any services before a contract, a service agreement has been executed. There's a couple of reasons for this. One, without the service agreement in place, the brokerage has no authority to carry out any work on behalf of the corporation. And secondly, insurances aren't in place until there's a service agreement signed and executed between the parties. I'll come to the insurance issue later on, but one of the significant issues is that a corporation has to carry insurance for fraud and dishonest acts, and that insurance has to cover the board, its employees, and any third-party management company. And if there's not a contract in place between the corporation and the brokerage, then that insurance would not apply. So RECA is insisting, making it mandatory that before any services are provided, there must be a written service agreement in place. Disclosures and transparency are very important requirements in a regulated industry. So in this section, we're seeing that there has to be disclosure in writing prior to there being a written service agreement if there's any conflicts or potential conflicts of interest that could exist. And they have to get, the brokerage has to get written consent from the corporation in order to proceed if there is any conflict. So there may be some form of a potential conflict, for instance, would be that the broker or the condominium manager at the brokerage own a unit or units in that particular corporation that they're going to manage. In most cases wouldn't be a conflict at the end of the day, but that has to be disclosed because it potentially could be a conflict, and it's up to the board to decide if they have any issue or problems with that. And if they're okay with it, then they would simply sign off a simple disclosure that that was disclosed and that they're okay with it. They also, prior to a service agreement being signed, the brokerage has to make it clear how it will be compensated. So that would include any monthly service fee they're charging, as well as the addendum that I mentioned previously for the extra services. So the corporation needs to know prior to entering into the agreement what they're going to be required to do, to pay, what it's going to cost the corporation for these services before they sign and commit themselves. Also, prior to acceptance of any other money or benefits by the brokerage, they would have to disclose these benefits to the corporation. So this could be from third parties that are going to be contracted to provide services for the corporation, such as the snow removal or the landscaping, from expenditures made on behalf of the corporation. So we do know that there are some models out there, both in property management and condominium management, where there's a markup of a certain percentage point on everything that's provided or done on behalf of the client, the landlord in property management, or the corporation in condominium management, and any other factors that influence the payment of monies or benefits. An example would be if the brokerage happens to own a company that also provides landscaping and snow removal services, and that's who they're going to use to provide those services to the corporation they're going to manage. There's nothing wrong with that happening, but the brokerage has to inform the corporation, the board of directors of the corporation, that that there's an ownership interest, or the principles of the brokerage are the same principles of the landscaping company. That has to be all disclosed up front, so that, again, the board is aware of it. If they're okay with it, and it can go ahead, but it has to be disclosed. There cannot be what's known in contract law as secret profits. So a condominium manager or a condominium management brokerage cannot benefit in providing services to a corporation in other ways other than what they've contracted with the corporation, unless the corporation has agreed to these other benefits or remunerations. So no secret profits. And then prior to entering into the contract, they have to disclose any other factors that might influence the decision of the board in going forward with a service agreement. So an example of this would be, let's say Condominium Corporation is looking at hiring a new condominium management brokerage that they've not dealt with previously, and they're in talks about this, and but they're not aware that this brokerage is in the process of finalizing a deal with another condominium management brokerage to amalgamate the two and merge the two brokerages together as one. And this could have might have an effect on the corporation that the brokerage is trying to get under contract, because that corporation should know about this potential merger. The issue may be that they may have dealt previously with the other company that's being merged into this brokerage, and they may have had bad experiences and not want to deal with that other brokerage. So it would be important for the brokerage that they're talking to let them know that this is happening. And I can tell you personally, I saw this happen in the instance of where I live, that we were given notice well in advance of a major merger that was taking place between two large condominium management firms. And we would have known about it well in advance and been able to raise the issue if we had any concerns. So again, it's disclosure. It's so a board can make a decision as to whether or not it's in their best interest or not to move forward. And then if there's any changes afterwards, once the service agreement goes in place and something has changed on the brokerage side, that could be a conflict of interest, they must disclose that to the corporation, and then the corporation would discuss it. The board would discuss it, and if they had any concerns, they would express their concerns. But there would have to be written acknowledgement that this issue was brought forward to the board, and there was written consent for everything to move forward. Condominium manager brokerage must not do these specific things. So we call them prohibitions under the rules. So they cannot employ or engage somebody that's registered or licensed with another brokerage. So the way it works under the regulatory structure of RECA, a person who is licensed at one brokerage in a particular sector, so in the condominium management sector, a person can only be licensed with one brokerage and can provide services on behalf of only that brokerage. And then the brokerage cannot employ a person to provide services that require a license, and the person they're having carry out those services is not licensed. So that's a very significant breach of the rules. And that ties back to one of the general issues that I mentioned earlier, that you can't assign duties to administrative staff or assistants that require a license unless that person happens to be a licensed person carrying out administrative support or acting as an assistant. And also the brokerage is restricted in how it can pay it compensation or pay out funds that it earns. So it can pay referral fees or share fees with another licensed condominium management brokerage if it chooses to, or with some brokerage that's licensed under similar legislation in another jurisdiction. So that's acceptable. And there's an oddball one here, Section C, subsection A, that allows a brokerage to pay a licensed employee of the brokerage through a personal corporation rather than paying that person directly. So some people might want to take advantage of tax rules, so they set up a personal corporation. And as long as that person, that condominium manager, sets up a personal corporation that they own 50% or more of the corporation, then the brokerage can pay their corporation rather than them as an individual. So it's a little bit of an oddball situation, may not apply in most condominium management situations, but it is an option that's been made available. Also under prohibitions, the brokerage cannot agree to pay out remuneration or referral fees to someone that's required to be licensed but is not licensed. So it typically would be referral fees that this would tie to. So if the person is carrying out some kind of an activity that is a licensed activity, then the brokerage, and they're not licensed, then the brokerage cannot pay them a referral fee. Likewise, in section E here, again, it's a bit of an odd one that many people wouldn't understand, but we see situations like this happen from time to time where a brokerage may pay out a commission or remuneration to another brokerage, but they have knowledge that the other brokerage is going to share that commission or remuneration with somebody who is unlicensed, but who is carrying out licensed activities. So if the brokerage was aware of that, they're not allowed to pay that commission or that remuneration to the other brokerage. Then lastly, on the prohibitions, they cannot enter an agreement whereby there's a clause in the service agreement that relieves the brokerage from its liability for negligence or other tortious conduct. So we've seen instances in condominium management contracts where they put a clause in that says the brokerage will not be liable for any of its activities. Well, in a regulated industry, that's just not allowed. The regulated person and brokerages are responsible for their actions and are held accountable under the Real Estate Act, the regulations and the rules, and they can't pass that off to a condominium corporation, for instance. So that type of a clause is not allowed. So the broker, who I mentioned earlier, is the person responsible for supervising the activities of the brokerage, has to be actively engaged in the management of the brokerage. They can only provide services through the name of the brokerage. So a broker can't be operating and providing services outside of their brokerage. They always have to make sure the name of the brokerage is clearly indicated in everything they do. And a brokerage is required at RECA to have a written policies and procedures manual. And it's a general operations manual that goes further than the act and the regulations and the rules. So this is how that particular brokerage operates, what that company's policies and procedures will be. So every brokerage is required to have one of these, and it covers off a lot of different issues. And I'll come to one of them later on when we're talking about some other things, and you'll see how it ties in. And then, of course, the broker is to ensure the business is carried out competently in accordance with the various pieces of legislation and rules. Under the broker responsibilities, again, the broker is held responsible at a high level. So they're to ensure there's an adequate level of supervision. They ensure that money held in trust is held in accordance with all the rules that are in place for trust funds. They have to ensure control over the accounts, including access by automatic bank machines. So RECA does not allow a card for an ABM that is used in conjunction with trust accounts to be able to be used to withdraw funds directly from an ABM. The card only allows to do deposits and transfer of funds between accounts. So again, the money just can't be withdrawn, and it's not accounted for. When it's restricted to deposits and transfers, then the money is always traceable as to where it's come from, where it's going. The broker has to ensure proper management and control of documents related to licensing, registrations, and any other regulatory requirements. And then there's a requirement that documents and records be maintained in Alberta, and for a 3-year period is what the rules currently say. And so it applies also to condominium management. So at a minimum, a manager has to keep the records and be made available in Alberta. So if RECA is doing a practice review or is doing an investigation, then all the documents for the previous 3 years have to be available for review. And then the broker is also responsible for reviewing all management agreements and also any condominium corporations contracts that are taking place, so that there's a second set of eyes beyond just the condo manager responsible for that particular corporation. The broker should be overseeing to see that things are being done correctly and that there's attention to detail. This piece around the broker responsibilities is to ensure that the broker has authority. So it's not an issue when a broker has controlling interest. So they own the brokerage or they own more than 50% of the brokerage, then it's not an issue. But there are instances where brokers get hired as an employee of the brokerage and they do not have any ownership position or they own less than a controlling interest. And if that's the case, then there has to be a document signed by the principals of the brokerage stating that they will allow the broker to carry out their activities as a broker without interference. So this is very important because it's the broker that gets held responsible for the operation of the brokerage, not the principals behind the brokerage that may own it. It'll be the broker that's held responsible. So when we do look at a brokerage and a broker, when there's problems or issues, and the way we look at it, should a conduct issue arise, for instance, RECA would look at the issues listed here to determine if the broker was carrying out their function properly. So as we say, they're accountable for the conduct of the employees at the brokerage. So was the brokerage actively involved in the day-to-day management? Did they ensure there was an adequate level of supervision? Was the broker a participant in the misconduct? Or if they weren't a participant, did they have knowledge of the misconduct, but they failed to take reasonable steps to stop it? And then when they did become aware of it, did they try to reduce any harm that might have been caused by the misconduct? So all of these things are important when we look at an issue, a problem that's come up, a complaint, to see that the broker was acting appropriately. And then lastly, the broker has a requirement to report issues of fraud, deception, theft, or unlawful activities to the executive director of the real estate council. This is so that RECA is aware of an issue when it happens. So if it was fraud, so RECA would be aware that a fraud issue has happened, and it would give, by RECA knowing about it, we would be able to look into it in more depth to see who was involved. Was there more than just one person, for instance? Was the brokerage actually involved in the fraud, or was it they were affected by a fraud caused by somebody outside of the brokerage? But RECA cannot look at these things if it's not aware of it. So it puts a high level of reporting on the broker to report these things back to the real estate council. The broker can delegate responsibilities to another licensed person at the brokerage. And this could happen for numerous issues or reasons. One would be that the broker may be going away on vacation or have to take extended time off because of a medical issue. Any number of reasons like that. Or in the case of large brokerages, it might just be too much work for just the broker to carry out. And so they want to delegate some of the responsibilities to another person licensed at the brokerage. So if that's the decision of the broker to delegate some responsibilities, they would have to first determine who they feel is qualified to carry out those particular responsibilities, and then sit down with that person, go over what would be delegated to them, make sure that they understand it and are in agreement with carrying out that delegation, and then it would have to be detailed in writing as to what the delegated responsibilities will be, and that the delegated person understands it and is agreeable to it. So that would all have to be documented in writing. And then once the delegation is in place, they would have to communicate that to the employees and the associates that are affected by the delegation, so that they know the person who's been delegated actually has the authority granted by the broker. And then the broker has to maintain a system to supervise and monitor the delegate to make sure that things are being done properly. Again, because it's the broker that's always held responsible at the end of the day. This rule details the responsibilities a condo manager has to their broker and their brokerage. So I first talked about the responsibilities of the brokerage. Then I talked about the responsibilities of the broker, the supervisor. And now we're talking about the responsibilities of a condo manager, the frontline person typically working with condominium corporations. So this person, as a licensed person, can only provide services in the name of the brokerage that they're employed by. They have to ensure that all the documentation that they're working with meets the requirements under the Act, the regulations, and the rules and bylaws. They have to report back to the broker with copies of any documentation and contracts, etc., that they're working with. The brokerage can't supervise if they don't see what's taking place. So all documentation that the condo manager has working with a condo corporation is the brokerage's documentation. It's not the individual condo manager's documentation. They have to keep their broker informed of their activities, and if the associate, the condo manager, has an assistant or is responsible for supervising any of the administrative personnel of the brokerage, then they have to ensure that they're supervising them properly. And then lastly, if they become aware of any violations of the Act, regulation, rules, etc., they have to report that to the broker. So the broker can assess what the issue is and report back to RECA if necessary. And then as there were for the others, there's prohibitions for condo managers as well. So the condo manager cannot provide services to a condominium corporation except through the brokerage that they're licensed with or registered with. They cannot promise to pay any kind of a fee, remuneration out to another person or another brokerage, or accept commissions or fees or any type of remuneration from another source except through the brokerage. So all monies have to be paid, either paid out or received by the brokerage, never by the individual condo manager. Everything has to be accounted for through the brokerage. Lastly, the individual condo manager cannot advertise any form of an incentive provided for by the brokerage or on behalf of the brokerage unless it's been approved by the broker and it's being offered by the brokerage. So incentives are when something of value is offered by a brokerage in an attempt for people, and in this case it would be condominium corporations, to do business with the brokerage. So you might have a situation where a brokerage, let's say in the city of Calgary, is looking to expand its business, and it wants to do an advertising campaign out to a lot of condominium corporations that it's not currently doing work with. And so it wants to promote its services. So it can offer an incentive to get corporations to come and talk to them and discuss further. So an incentive would be something of value. So they're offering something of value to entice the board of the condominium complex to talk to the brokerage. And that's fine, they can do that, but it can't be something created just by a condo manager and offered by a condo manager. It has to be from the brokerage, by the brokerage, and approved by the broker. Part two of this, which is something that in the industry often gets confused with incentives, is inducements. So an inducement is when a brokerage is in direct negotiations with a specific condominium corporation and the brokerage is offering something of value to go ahead with the contract. So a brokerage may be having discussions, negotiations with the condominium complex about going forward with a service agreement, and the brokerage offers something of value to the corporation to entice them to go ahead and sign a service agreement with them. Again, that's legitimate, it can be done, but it has to be, again, a brokerage approved inducement, and it has to be approved by the broker in writing. So that only happens, this inducement only happens between a specific condominium corporation and the brokerage. It's not a broad-based advertising as it is in the case of an incentive. And then the last piece here on this slide, the brokerage shall not provide services if there's any kind of a conflict of interest. Again, there's a theme that runs through the rules around disclosure and conflicts of interest. So they have to disclose if there's going to be any form of a conflict of interest, have discussions with the client. In this case, it would be the board of directors of a condominium corporation, and receive written informed consent before proceeding. The next piece are the obligations that a brokerage has to condominium corporations. So although this rule details specific obligations, as I mentioned earlier, RECA is principle-based and looks not only at the specific obligation, but did the industry member also meet the spirit of the obligation? So these would include using their best efforts to manage the corporation, obey the lawful instructions of the board of directors of the corporation, exercise reasonable care and skill in how they do their work, assist the corporation in negotiating favorable terms and conditions with third-party contracts. And this is one that is very important, in that the favorable terms and conditions should be on behalf of the corporation and not what's of benefit to the brokerage. It's always what's in the best interest of the corporation, the client, not the brokerage, that they should be looking at. To provide in a timely manner all reports, and I mentioned that about the reporting process earlier, and we'll come to a rule that says what reports must be provided as a minimum. And then section F here is about expert advice. So condo managers, we have seen instances where they kind of step outside their authority and take on the role of an expert in some situations. And we see it happen as well in the real estate industry, brokerage industry, where sales associates take on and give advice that's beyond their credentials and their experience. So in the case of condominium managers, a couple examples would be, for instance, making amendments to bylaws. So this year is a really good example, in that the provincial government put in place new regulations that came into effect on January 1st, and that's required a lot of corporations to make changes to their bylaws. So the vast majority, if not all, the condo managers that are out there working now in this environment are working with boards of directors on revising bylaws. And the condo manager is a good resource, would be very knowledgeable, have experience with numerous corporations in dealing with their bylaws, and can help the board of directors in assessing various issues that need to be dealt with in the bylaws. But at the end of the day, when a draft bylaw is pretty much put together, the condo manager should be recommending that the board get expert legal advice from a lawyer that is experienced in condominium law, and should not leave it with, a board should never be left under the impression that, well, if the condo manager is good with the changes we're going to make to our bylaws, then everything should be fine. That's not the case. It should always, changes to bylaws should always go to a lawyer experienced in providing advice around condominium matters. Likewise, if the corporation was dealing with a structural issue or a major envelope issue with the property, they should be, they can have discussions with their condo manager. The condo manager might be very experienced in previous instances of that have happened in other corporations with similar structural issues or envelope issues. So again, the condo manager can help the board along in their discussions, but at the end of the day, there should be a recommendation that the board get expert advice from a structural engineer, for instance, if it's a structural issue or envelope issue for the building, and not relying solely on advice by the condo manager. And then before a condo manager can sign a contract on behalf of the condo corporation, they have to have written authority from the board. So this could be built into the service agreement that's signed initially between the brokerage and the corporation, or it could be another document that's been added at a later date, or an amendment to the agreement, the service agreement. But there always has to be some form of written authorization giving the condo manager the ability to sign contracts on behalf of the corporation, if that's what the board desires. And then lastly, condo managers have to comply, as all the other regulated entities do, with the Act, the regulations, rules, and bylaws. This rule around disclosure of ownership is to ensure that the corporation is aware that there could potentially be a conflict of interest should a manager own one or more units in a corporation they would be managing. So, so if they own a unit or units, they must disclose in writing to the board this is the case. So any conflicts that they might have, they have to disclose that they're authorized or licensed under the Real Estate Act. They have to make sure that the name of their brokerage is provided as part of that disclosure, and any other information that could affect the decision of the kind of the decision that the board is going to make about this person actually providing services. So this is an interesting one because we've been getting feedback on the survey on this consultation, and had numerous comments from people that thought this wasn't a necessary rule because all boards of directors would know if the person that they're dealing with as a condo manager is a unit owner in that complex. And I would beg to differ because there are complexes out there that are 250, 300 units plus, and a board of directors isn't necessarily going to know if a person licensed under the Real Estate Act happens to own a unit in their complex and is also working for the property management company that they're looking to engage. So again, it's transparency, upfront disclosure, so that criticisms can't come back later by people saying, well, we didn't know. If we had known at the time, we might have made a different decision. So it's an upfront, transparent disclosure. This rule is regarding a very specific situation when an industry member owns one or more units and will be providing on a voluntary basis condominium services to that condominium corporation. So when I mentioned the exemption regulation early on in the webinar, that the government would be approving certain exemptions of people who will not require a license to provide management services. This was the last one on that list. And so this is a very important rule, and it's one that if a corporation is going to go forward with this voluntary management issue, they need to make sure they're fully aware of the ramifications of that decision. So the rule is pretty blunt. So I've used the term voluntary several times in describing this. So this is when somebody owns, as I said, one or more units in a condo corporation. And the first one says that they must only provide services to a maximum of 2 corporations on a voluntary basis. So you could conceivably have a condo manager who has been doing investing over the years in condominium units as rental units, and they may own one or more units in 3 or 4 different corporations, which is fine. But if they're going to volunteer their services, they can only volunteer in a maximum of 2 corporations where they own a unit to restrict their involvement. So they have to disclose in writing certain key issues to the board prior to this being agreed to. So they have to disclose that they will not be acting as an industry member. So they will not be acting in their licensed capacity working for a brokerage. They have to state that they will not be regulated under the Real Estate Act in providing these services. And that the corporation, the condominium corporation, is not entitled to the same protections that are available if they were working with a condominium management brokerage in a licensed capacity rather than somebody in a voluntary capacity. So these are all very important. So the same protections would include the act and the regulations and the rules would not apply to this person. Although they're licensed, but they're acting in an unlicensed capacity, these rules would not apply. There would not be the supervision of the broker. There would not be the administrative support of the brokerage. The insurances that the brokerage carries, such as errors and omissions insurance, would not apply to a person who's working for the brokerage, but providing voluntary services to a corporation. So before a board makes a decision to go ahead with this, they need to consider all of these things and think, is it in the best interests of the corporation? It may save money, but at the end of the day, is it in the best interests of the corporation, sorry. Also, other steps that have to take place in this situation is that the individual that's going to provide the voluntary services has to provide their broker with a written disclosure that they're going to be doing this. So the broker has to know that this person who works for them is providing voluntary services to a condominium corporation. Now, this ties back to the policies and procedures manual for a brokerage that I mentioned earlier. So the policies and procedures manual at a brokerage could in fact have a statement in it that says any licensed condominium managers of the brokerage are not permitted to provide any condominium management services outside of the brokerage. So the brokerage may want to protect its position, its reputation, and to ensure that any activities that might get tied back to them are done properly. So they may forbid anybody that works for them from providing voluntary services outside the brokerage. And if that was the case, then a condo manager that worked for that brokerage could not take advantage of this exemption and provide voluntary services. Other stipulations are that the person providing these voluntary services cannot have sole signing authority on the corporation's accounts, and they must not receive any type of compensation for their voluntary efforts or benefits. So they can't be paid, and a benefit that might get offered, for instance, is, well, we'll only charge you half of the fee for your condo unit in the corporation, or we'll waive your condominium fees for the unit you own. Well, that's clearly a benefit to the person, and that would not be allowed under this rule. And then lastly, if this person was providing these services, they have to, on receipt of any funds on behalf of the corporation, see that they're turned over to the corporation quickly, promptly. And this would typically mean they would have to be deposited to the corporation's bank accounts once received. So that takes me to the end of the second section that covered responsibilities, obligations, prohibitions, and a few oddball situations. So are there any questions on what I've covered in this second session?
And no questions in the chat, Doug, but maybe if Jim or Rick have questions, they could ask you directly.
I got the thumbs up from Rick, I see, so I'll move on. Not hearing anything from Jim. So the last section deals primarily with record keeping, financial issues, and insurance. And this first piece is about record keeping. So as mentioned earlier, the service agreements have to cover this issue off, but there's a requirement specifically under the rules that the brokerage has to keep all condominium management records and make them available to RECA on request. So that's a high obligation of maintaining accurate records and keeping them for the required amount of time. And then also tied to record keeping and to service agreements is the minimum reporting, financial reporting that the condominium manager has to do back to the condominium corporation. So the bare minimum under the rules would be the brokerage on a monthly basis must provide the board of directors of the corporation a statement of income and expenditures, a balance sheet, and anything else that's been specified in the service agreement. So it's a very important piece for a corporation to think about when they're negotiating with a brokerage to provide services to that corporation. So what do we want the reporting to look like? So I can tell you that, again, in my personal situation where I live in the condo corporation, the management company that provides services to us provides the statement of income and expenditures, a balance sheet. They provide a detailed breakdown of what income and expenditures are against the budget and the variances. They also provide us with the copy of the month's ledger sheet for our corporation, so we can see all the expenditures that were made. And that's useful because you can have some categories that lump a number of things together. So in our case, there's the maintenance category and landscaping that's a category that's separate from the landscaping contract, but they could include numerous different items that come along on a monthly that are charged back in a particular month. So you might get a lump sum figure that shows up on the statement of income and expenditures, but it's made up of several different items. So when you can see the actual ledger sheet, you can look and see what each item that has been paid out on behalf of the corporation. So it's very helpful. Also, we get an update every month on what investments are being held by the manager on behalf of the corporation. So I think this is an issue that many corporations don't pay nearly enough attention to when they're entering into service agreements. They should be thinking about what do we want to know about on a regular basis on the financial side of things. So the next piece is about the funds of the corporation and how they're handled by a property manager. And to bring some clarity, it's important to understand the different types of accounts being discussed and the appropriate signing authorities for each one. So the first one I just want to clarify is the brokerage operating account. So this is money of the brokerage. This is not condominium corporation money. So the corporation earns fees from the corporations that it manages. So those fees, when they're earned, are transferred from the corporation into the brokerage operating account. Then the brokerage pays its employees, they pay for their own operating expenses. Never should anything that's an operating expense of a brokerage get paid out of a condominium account or a trust account. Always out of the brokerage's own operating account. The signing authority for that operating account would typically be the broker and any employees that the broker has assigned signing authority. The middle one here in green is brokerage trust accounts. So this is when the brokerage holds condominium corporation funds in trust in bank accounts that are managed directly by the brokerage. So the signing authority would typically be the broker. Our rules require that the broker must be a signing authority on these trust accounts, and any designated employees that the broker is comfortable having as signing authority on these accounts. So one of the things we have found, and I'll mention the third category first, condominium corporation accounts. So in some instances, the brokerage does not hold money in trust accounts. All the corporation's money is in corporation bank accounts, but the corporation has given the condominium manager authority to manage the funds in the corporation's accounts. So the signing authority can be quite varied under corporation accounts. It could be a couple of members of the board of directors have signing authority on the accounts. It may be a situation where the board wants the condo manager to be a co-signer with a member of the board on all checks written on expenditures made on the account. Or the board, through the service agreement, could delegate this responsibility totally to the brokerage and to the condo manager to be signing authority and manage these accounts. So again, it's up to the board of directors to decide what they think is most appropriate. But you've got two different situations where money is either held in brokerage trust accounts or the corporation's own trust accounts. And I can tell you there's no rule of thumb in the province of Alberta. In earlier discussions we've had, it became clear that in Edmonton, it's done quite differently in Greater Edmonton than it is in Calgary. So in Greater Edmonton, roughly 2/3 of all funds for condominium corporations are left in condominium corporations accounts and not held in trust. And in Calgary, it's the complete opposite. 2/3 of the condo corporations, their funds are held by brokerages in trust. So I don't know how that's developed over time, but it is quite different. But the option is there. And again, it's up to the corporation to decide, Do they want the money to be maintained in the corporation's own bank accounts, or are they okay with the funds being held in the brokerage's trust accounts? So I'll first go through the rules that apply specifically to the brokerage trust accounts. So this means the funds are not in condominium corporation accounts. They're in accounts maintained by the brokerage, and they're designated as trust accounts. So trust is a very important word. It's beyond just a description. Trust in this instance takes on a very strong legal connotation, and there is an act that deals with money being held in trust in Alberta. The Real Estate Act specifically deals around terms of trust, and also the Condominium Property Act deals with it as well. And then on top of all of that, all the institutions that hold funds in trust are governed also by the trust rules. So it puts a high level of protection in place for funds owned by a third party, in this case, condominium corporations, on behalf of the unit owners that are behind that condominium corporation. So in the first instance, when a brokerage holds trust accounts, funds in trust, they have to have one or more trust accounts. So a brokerage is not allowed to commingle money for operating accounts and reserve fund accounts. They're specified under the Condominium Property Act that they always have to be separated. So the brokerage, when holding money in trust, would typically have an operating account and a reserve fund account. And they typically collect the monthly unit assessments through the operating account, and then typically on a monthly basis would transfer the portion of the funds brought in from the condo units that goes to reserve. They would transfer a portion of that, as specified in the budget, over to the reserve fund money. So that at a very minimum, they would typically have these two accounts. But the rules do allow for the brokerage to set up more than these two accounts. So they can have other special trust accounts that they could label in different ways. So if there was a desire to have a special levy trust account, they could do that. They could have a third account just for a special levy. But our understanding is that the norm in Alberta is that when special levy money is collected, if it's being collected because there's a shortage in the operating fund, an example of when that might happen, for instance, there are some condo corporations in this past year or two that are struggling because insurance rates are coming in much, much higher than what they previously paid and budgeted for. So we've seen instances where an insurance premium for a large corporation has gone from $50,000 to $75,000 or $100,000 or more, and they had budgeted for a $50,000 or $60,000 insurance cost that year, and suddenly they've now got a bill that's double or triple that, and they don't have the cash on hand to cover it, so they end up doing a special levy of the unit owners. So in that instance, they would collect the special levy and typically deposit it directly to the operating account because it's going to be used right away for that purpose. Likewise, they could be collecting money for a special levy for reserve fund issues, for an issue that's happening with the complex, a serious issue. So that money, if the issue is going to be dealt with directly, right away, they might put that money straight into the operating account because it's going to go right back out again. Or they could put it in the reserve fund account if it's not going to be used immediately. And then they have that third option of actually putting it into a separate account just for levy money. Another instance where there could be a special trust account is when particularly a larger corporation might be dealing with a lot of rental units. So owners in that complex have units rented out, and most condominium corporations in their bylaws have a rule that requires on a rental for there to be a deposit made by the owner of the unit with the corporation, a deposit to cover any potential damage that a tenant may cause the corporation. So it might be easier in those instances to have a separate account just for deposits, so they're easier to account for. So again, the legislation is or the rules are flexible enough to allow a manager to set up a special account specifically for that purpose. So for each of these accounts, there has to be a separate ledger. Every dollar in and every dollar out has to be accounted for, and records have to be maintained. If any cash is received by the manager, it has to be deposited to the appropriate account, which would typically be the operating account, and they have to provide a written receipt to the person providing the cash. All checks have to be accounted for, so this would include void checks, checks that have been cashed, stale dated checks. Doesn't matter what has happened with the check, it has to be accounted for, so there's a complete record of what's taking place with that trust account. So when the brokerage is holding funds in trust on behalf of a corporation, it can only make disbursements or payments by check or bank transfer electronically. It cannot be by cash. The only time you might see cash come into things, and again, it's sort of an indirect thing here, is when a corporation, a board of directors, might have petty cash on hand to handle small miscellaneous issues, often expenses that a board member has incurred on purchasing something or doing something on behalf of the corporation. So if they keep let's say a $500 petty cash float, then that float is maintained by collecting receipts as money is spent, and when there's a need to replace the money in the float, then they would turn in all the receipts, and a check would get written from the operating account for the amount necessary to top up the float. So again, there's a check, and it's known that that money has gone to a float rather than to some other source. Again, it's so that money can be tracked at all times. A manager is not allowed to issue a check or attempt to transfer when they know that there's insufficient funds in the account. Again, because trust is treated so seriously, it's a significant flag for us as a regulator if we become aware that there's been an NSF payment tied to a trust account. That would raise flags and would require us to look into things more seriously. Now, it can be done. It can happen as a result of a simple mistake or poor bookkeeping, but it can also happen because there might be something inappropriate happening. So again, I said it raises a flag, and it's something that RECA would look at if we become aware that there's been an NSF issue with a trust account. All checks, in addition to being numbered, have to be identified with the words trust account, so that it's clear to everybody that handles that check, whether it be staff at the brokerage, the person receiving the check, a law firm, the bank who's going to be processing it. Everybody has to be aware that this involves trust funds. And then lastly, the broker has to ensure that they are a signing authority on all trust accounts. RECA, or under the rules, it's a requirement that the broker has to have access to the accounts, be able to talk to the institutions that hold the accounts, and that's only possible if they're a signing authority on the accounts. The broker can, depending on what's decided between the corporation and the through the service agreement with the brokerage, have other signing authorities at the brokerage that the broker has designated. So I'm going to flip now from trust accounts to when the funds are being held in condominium corporation accounts. So there are no trust accounts. The money is not being held in brokerage accounts. It's staying in the corporation's own bank accounts. But the brokerage is going to be managing these funds on behalf of the corporation. So you'll see that the rules for this are very similar, because the responsibilities of the brokerage are treated essentially the same, whether it's trust funds it's the brokerage or it's the corporation's own bank accounts, we take the same issues into account. So they would have to have separate accounts again for the different functions. So there would have to be an operating account, there would have to be a reserve fund account, and if necessary, if it was desired to keep special levy money separate and apart from operating and reserve, then there could be other special accounts for levies. Or as I described earlier, the corporation could have an account specifically for holding deposits on rentals. So all of those rules apply the exact same under the corporation's accounts as they do within the brokerage trust accounts. And with the corporation accounts, many of the flow of funds is the same. So they have to maintain a separate ledger for each account. They have to provide a receipt for cash, the same as in the other instance. They have to account for all checks. They have to do disbursements, as mentioned before, by check or by bank transfer for the same reasons. So there's a paper trail of where the money has come from and where it's going. And signing authority is a little different. Unless authorized by the Condominium Corporation, not be the sole signing authority on the Condominium Corporation trust accounts. So some corporations may sign over all signing authority on the accounts. Others may, as I said, keep the signing authority partly by the board, but regardless of what's done, the brokerage, the condo manager, cannot be the sole signing authority unless the board has given written authority, whether through the service agreement or some other written authority, that they can be the sole signing authority. So it's very important that the broker, the board of directors of the Condominium Corporation is always comfortable with the arrangements that have been made for the management of the funds of the corporation. So Rule 109.7 is a bit of an unusual rule for a very specific situation. In some instances, it makes sense for a brokerage to use an electronic deposit account to collect condominium fees and then distribute them to the appropriate account. So typically, in this day and age, when a brokerage is managing a condominium corporation money and they're collecting the funds from the unit owners, they would usually come electronically to the banking institution being used, whether it's trust accounts or whether it's the corporation's own accounts. And it would depend on how they're handled, on the capabilities of the bank or the institution that's holding these accounts. So some institutions would allow direct transfer of the electronic transfer of the funds directly into the trust or bank account, but in many cases that gets expensive to do it that way because there's a service fee for every single electronic transaction that takes place. So what happens is typically a brokerage would set up an electronic transfer account that they pay a monthly service charge for, and then they would run all the collection of monthly fees for that condominium corporation through that electronic transfer account. So the funds come in, they go into the electronic transfer account, and then automatically are transferred over to the appropriate account where they belong. This rule eliminates the need to set up multiple electronic transfer accounts for every corporation and trust account that a brokerage manages. This can eliminate multiple bank charges to a brokerage, which ultimately end up being an expense to condominium corporations. So this pooled, it's very important to know that this pooled electronic trust account can only be used if the corporation being managed approves a resolution to allow the brokerage to use a pooled trust account. So the board of directors can pass a resolution authorizing the brokerage to use a pooled electronic transfer account. Now, some people have a concern about pooled accounts, but this is a very different type of a pooled account. There are no expenditures or withdrawals of any kind that get made through this account. It's simply an electronic transfer account that allows money to be collected electronically from units in a number of condominium corporations. It all comes through the same electronic trust account, and the only place it can go is to be transferred to another bank account or to a trust account, a bank account of a condominium corporation or a trust account of a brokerage. And depending on the capabilities of the bank where this transfer account is located, some allow the money to come into the electronic transfer account electronically, and the money sits there until somebody manually moves the funds. So typically a bookkeeper at a condominium management brokerage would at the first of the month go into this account and transfer the money out of the account into the appropriate trust or condominium corporation account. Other banks or institutions have it set up in a little more sophisticated way that the transit coding that unit owners have to do their direct payment of their monthly fees has coding in it that when the money goes from the unit owner's bank account into this electronic transfer account, the coding tells that account specifically what bank account or trust account the money is destined for, and it typically within seconds transfers it directly into the appropriate account. So this is an opportunity to eliminate a lot of bank fees. So you have a large condominium management brokerage, let's say has 50 corporations under contract. All 50 corporations typically are going to be paying fees through electronic transfers by their unit owners. And if they all have to pay monthly fees for each corporation, and you multiply that by 50 corporations times 12 fees a year, it really adds up to a lot of money. So this is just to deal with that particular situation, and it's not a risk either in the trust situation or the corporation account. There's a clear trail of where the money's come in from and where it's going out to. So I mentioned termination of service agreements, that it's a requirement for service agreements, and this rule specifies what the minimum requirements are. And this rule applies to the natural termination of a service agreement. So it's the expiry date, but it also applies to situations where a service agreement may be terminated early by either the corporation or the brokerage. And most commonly it's going to be by a corporation that's not happy with the services they're receiving, and they've decided to terminate their agreement and move on with a different manager. But it can be terminated by the brokerage as well. We see situations where there's lots of governance issues with a board of directors, and it gets to the point of frustration for the condominium manager that the board is not carrying out business according to the Condominium Property Act or their own bylaws. And regardless of the advice they're getting from the condo manager and the brokerage, the board is choosing to go in different directions. And so a brokerage may decide in that instance that they want to terminate the contract. So if a termination is going to happen, the following things have to happen within 30 days. But the rule, as you can see here, it says as soon as possible, but no later than 30 days. And RECA's position is that the more important part of this is as soon as possible. So we will not allow a brokerage to simply say, well, we did it within the 30 days, that's all that was required. That's not the case. One of the biggest complaints and issues that we receive around both in property management and in condominium management is when there's an early termination, which is usually happening because somebody is disgruntled. Typically the board is not happy. And when they've decided to terminate, often the brokerage is not happy that they're losing the business. So the brokerage sometimes drags its feet on doing certain things. And this rule will prevent them from dragging their feet. So as soon as possible, when it comes to money, means that the money should be transferred as soon as possible. Section 2 of this rule allows the brokerage to retain sufficient funds to pay any outstanding invoices that are in progress. So if there's already payments in progress, then the brokerage can withhold that amount of money to cover the outstanding checks. But the rest of the funds in the operating account and the reserve account can be transferred. So typically we would expect within a week to 10 days that any unneeded funds by the manager must be turned over as specified, and not just simply held for 30 days because the broker felt they could hold it for 30 days. So there's three options that the corporation has in directing where the funds go. So in the instance of where the monies are held in trust entirely, then the corporation could instruct the brokerage to transfer all the monies back to the corporation's bank accounts. The corporation could instruct the brokerage to disperse the funds to the corporation. Or sorry, that would be if the second one, the dispersion, sorry, I got that confused there. The dispersal would be if the funds are held in trust, then they could order that the brokerage return the funds to the corporation. The first one, the transfer of control, is in the instance should the brokerage have control of the corporation's own bank accounts, then they must transfer the control as soon as possible to the board of directors. And the third option that the board of directors has, if they're going to be taking on a new brokerage to manage the corporation, and they've signed a service agreement, because they can't instruct this unless they've got a service agreement in place with a new brokerage, they can instruct the old outgoing condominium management brokerage to transfer the funds to the new condominium managed brokerage that the corporation has employed. So they have those three options, and these things should all, the bulk of the funds should all be transferred in the first week to 10 days. And then the last piece is that at no charge, the brokerage must return all property of the corporation back to the corporation. So this could be keys, key fobs, plans, survey documents, any number of things, and then the regular accounting documents all have to be turned back to the corporation, and there can't be a charge for that. So the brokerage can't say, well, I've got a photo, I have to keep copies of these documents, and I'm going to photocopy them, and I'm going to charge you for the photocopying. The brokerage cannot do that because the documents and the property all belong to the condominium corporation in the first place, so they shouldn't have to pay to get their own property back. So the last piece around the financial is that if the brokerage is receiving money for other business it's doing, it has to keep that other money completely separate from any money it's holding in trust on behalf of condominium corporations. So there cannot be any commingling of other business that the brokerage is doing with the condominium management services they're providing. You cannot commingle those funds. As I mentioned earlier when I explained the different types of accounts, the brokerage cannot pay any of the brokerage's own expenses out of the trust accounts or the corporation's accounts. They have to pay the brokerage's own expenses out of their own general operating account. Then the last piece here, if sufficient funds are available, the brokerage is required to withdraw their monthly fee from the trust account. So if they're holding the funds in trust, they're required to draw that money out on a monthly basis as long as there's a balance that covers it. And that's specified for a couple of reasons. One is if it's in the money is in a trust account, once the fee has been earned by the brokerage, so the month has gone by, they've earned the fee, then it's no longer trust money. So it can't remain in a trust account. So that's one reason for doing it. But we've seen instances where brokerages have left money in service fees for various reasons in the trust account. We've seen it because of sloppiness, where they've not, it's not been withdrawn. We've seen it where the broker just says, well, I don't need the money at the moment, so I'll just leave it there. We've also seen instances where a brokerage is having financial issues and there's third-party creditors at their door, and or CRA, and they've left the money sheltered in the trust account because it's kind of invisible to everybody else when it's in the trust account. And again, that would not be permissible under our rules. And in fact, it would be even a more serious issue in that that might be considered fraud by keeping the money there in order to prevent it from being visible to other parties. So it can't stay there. The last piece of the webinar is around insurance. There's two types of insurance. There's errors and omissions insurance, and there's fraudulent or dishonest acts insurance. So first, under errors and omissions, the decision was made previously in that phase one that I talked about back at the beginning in the overview, that condominium management would not be covered under RECA, the Real Estate Insurance Exchange. So that's a self-insured program that's in place for the real estate brokerage industry, but the decision was made by council that they would not include condominium managers and condominium management brokerages under that errors and omissions insurance program. The condominium management industry is a very different issue, very different exposure, and as a result, the decision was made that brokerages doing condominium management will have to go to market and get a policy for errors and omissions insurance. That policy has to be in a form approved by the executive director of RECA. It has to be a minimum of $1 million coverage. It has to be in effect as long as the brokerage is licensed, and certainly anytime it's carrying out any activities and providing management services. If at any time the insurance is terminated or canceled, then they have to notify the executive director at RECA immediately. Typically what would happen is they would no longer be able to provide any management services to any condominium corporations they have under contract, and their license to operate would be suspended until they replace the insurance and have coverage for errors and omissions back up and running again. So this is very important for the protection of the clients, which are the condominium corporations, that there be errors and omissions insurance in place. The second insurance that I mentioned is fraudulent or dishonest acts insurance. It's a very important insurance because there's huge money involved with condominium corporations. Some condominium corporations have very big operating accounts, let alone the money that they hold in the reserve for the reserve fund for long-term expenses for their asset maintenance. So in some, there's tens of millions of dollars in some corporations' cases being held. So this insurance is very, very important. Of all the rules, though, in our discussions and in the consultation, this one has generated a lot of discussion. I also believe there's been much misunderstanding around the issues tied to this particular rule. As a result of the changes made to the Condominium Property Act regulations that came into effect back in January 1st, the committee changed its position on bonding of brokerages. So previously in the draft rule versions that we were working with, there was a requirement that brokerages providing condominium management services would have to carry bonding. The bonding has been taken out of the language in both our rules, and it's not bonding is not mentioned under the Condominium Property Act regulations. And I think that's a good thing because a lot of people didn't understand what bonding really was. And they've replaced it with the term fraudulent or dishonest acts insurance. So that's very plain language and people understand what that's about. And so we had that requirement for this insurance or bonding in place previously, that the brokerage would have to carry that when they're carrying out condominium management services. But when the change to the Condominium Property Act regulations came into place, that regulation for condominium corporations requires every corporation to carry insurance for fraudulent and dishonest acts. The insurance must cover the board members of the corporation, any employees the corporation employs, and any third-party management brokerages the corporation hires. So requiring a brokerage to also carry bonding or similar insurance creates a duplicate expense for condominium corporations, because if the condominium management brokerage has to carry this coverage, they're going to build the cost of that insurance into their overhead, which then gets distributed back out in the fees that they charge back to condominium corporations. In addition, if this insurance is made by the brokerage, it insures the brokerage and not the corporation. So you get into, there's a couple things that can happen here. So under the regulations under the CPA, the fact that the corporations are required to carry this insurance is a good thing. For one, it makes sure that all corporations must have this insurance in place. Secondly, if there is ever a claim for any reason, and that when that claim is paid by the insurer will be paying the condominium corporation directly. Whereas if it was going to be handled through coverage that was being carried by a brokerage, then the brokerage would have to make the claim, and the claim is being paid by the insurer to the condominium management brokerage, not to the corporation. Now, if you think about it, if there's a claim for dishonest acts or fraud, there's something wrong happening at the brokerage that's caused this to happen. And if it's caused serious financial issues for the brokerage, then it could be, even though the brokerage is getting paid back some or all of whatever the claim is, it could cause complications, and it would put potentially a condominium corporation in a legal position where they may have to take legal action against the brokerage to get their funds replaced. So the system that's been set up by the provincial government, tying it to the regulations and requiring the condominium corporations to carry the insurance, actually resolves a whole bunch of these issues, and it just makes more sense and a better flow, and financially it's in the best interests of the corporation as well, from an expense point of view. So that brings me to the end of the proposed rules.